Periscope and the application on a mobile device. It will not work on a laptop or a desktop. But remember that you can chat with us on these broadcasts while we're live. So if there's something you want us to cover or you want us to clarify after we've talked about something, just type it into the chat box. And if we don't catch your message as it streams by, because it goes by pretty fast, the first time, then just type it in again. You can type it in as many times as you want. Just so you know, there is a lot going on to produce this Periscope broadcast, so please be patient with us if you need to put that question in 2 or 3 times. Also, if you think that your followers on Twitter and Periscope might want to learn and could learn from what we're covering in these broadcasts, by all means share. You can share these broadcasts with the people following you. One other thing, I do have a goal of 5,000 hearts this month. So if you hear something like, well, actually it's down in the right-hand corner of your screen. If you just tap it, I don't think there's anything actually down there, but if you tap the right-hand corner, lower right-hand corner of your screen, it will create these little hearts that pop up, and those are ways that Periscope judges the value of these broadcasts. So please be generous with your taps if you like what we're talking about. I want to mention something different from last month's broadcast. I do have Andrew helping me, and Andrew is my marketing director for my company, Land Trust Made Simple. He's providing a bit of technical support for us today. He's also got an eye on the comments section, so he may be interrupting Lynda and I once in a while to read a question from you to us, because it's just too much to try to talk about these subjects and cover and watch those questions fly by too. So now the reason why we're all here today, I want to reintroduce Lynda because we have a lot of new people on the broadcast today. And I think it's important that they all know who Lynda is. So, Lynda, I want to ask you if you could please reintroduce yourself as far as your qualifications. I know you have a company called Asset Century, ALC. In addition to that, you are a licensed attorney in the state of California. You've got your master's in business administration, and you're known as one of the leading attorneys in North America on philanthropic transfers of wealth. And I know you also work for a lot of nonprofit companies and organizations. So you do cover lots of different kinds of trusts. I know that. We're only going to cover the land trusts in these broadcasts for right now. But if you'd give just a little more background about what you do and what you like doing in your business, please.
Okay. Well, first, I've been in business in the law practice for 39 years, and I don't go to court, I don't do litigation, I do mostly wealth advising, and I work primarily on specialty trusts. So in the area of philanthropy, I work with charitable remainder trusts, charitable lead trusts, private foundations, I work with public nonprofit, public charities, and I've done that all my 39 years, and I've done a variety of estate planning trusts during that time. And then about 15 years ago, I started looking at investing in real estate for myself. And that's when I discovered that there are different types of vehicles to use for my own investing, and started to learn a lot about different uses of land trusts and LLCs, and I'd heard a lot about land trusts. And when I started to figure out that land trusts were something that were going to be very beneficial to me, that's when I met Randy, because I started looking up, what are land trusts? How can I really learn about them? I actually had a hard time at first finding out what is a land trust and how do I use it. So then as I went to Randy's class, I actually went to the class and met Randy, and we became friends, and now we've been friends for many years. And we do a lot of work together in the land trust area, and we use LLCs and personal property trusts and limited partnerships and all sorts of business entities that real estate investors use. So now that has become a specialty of mine as well. And then I do some other kind of interesting sideline trusts, like pet trusts. We have pet trusts in California, or gun trusts. But I really specialize in specialty trusts. I don't do a lot of the basic living trusts.
Okay, I'm not sure we said, but you're located in San Diego, California.
Right, San Diego, yeah.
Just a couple of housekeeping things, and I want to ask you to address an issue that came up from last month's broadcast, Lynda. Somebody had asked for a list of portfolio lenders in the Chicago area that you could use to borrow money using a land trust, that are familiar with how to do that. And we'll be putting up on the Land Trust University website this next week that list that I've been accumulating. It's not a very long list, and it's not very wide country-wise, but it's everything I've got. So if you out there know of any portfolio lenders that will lend using a land trust, please send me an email and let me know, and I'll add that to the list so we can all benefit from it. My email is randy@mrlandtrust.net.
Randy,
yes.
This is Andrew, and CAPT 59, like Captain 59 says, exactly. I've only found one attorney that understands, one attorney / lender that understands, so he recognizes the value of these lists that you have on your Land Trust University.
Thank you for that. He's exactly right. I also would suggest that if you haven't done this on the last broadcast, if you didn't do it on the last broadcast, that you do it for all future broadcasts, is print out that 5.0 Land Trust Agreement so you can follow along with us. I print it out, staple it, and then you can mark it up as we're going through it, and when we're done, you'll have all the answers to all your questions about each paragraph, as opposed to just listening to this and trying to soak it up or something on the fly. And as a final reminder, these broadcasts are recorded, so you can listen to them again, or if for some reason you can't make a future one, you can always just follow me at Randy at Mr. Land Trust on Periscope, and you'll be able to see and review all the broadcasts. Now, Lynda, from last month's topic, we talked about the three preambles to the Trust Agreement 5.0 version. And you had some issues come up since then regarding an escrow agent and grantor and non-grantor issues. So could you clarify that, please?
Yes, one of the preambles, the real estate investor that we're addressing here, who's setting up the land trust, has decided to use the one where his or her name does not appear on the first page as the trustor or the grantor of the trust. But it just says that this is an agreement between the trustee and the beneficiary herein. I have a client that does exactly that on all of their land trusts. And just recently, one escrow company said, this can't be a grantor trust because there's no name in that paragraph that says the person is a grantor. And those are two different concepts. And this relates to solely in California, the 3.3% withholding tax on a sale. You know, when property is sold, when real estate is sold, unless you have an exemption on what's called Form 593C, you have to let the escrow agent withhold 3.3% of your sales proceeds. Now, this client has never faced that before. So the problem that we're facing, this is not resolved yet, but I mean, it's resolved in the law, but we haven't convinced the escrow company that this is the law. Grantor, when you label somebody a grantor, that means they're putting the property in the trust. But grantor trust has a different definition, and that is the person who has the right to revoke or various other rights over the trust. And in California, if it's a grantor trust, then there's an exemption from this withholding of 3.3%. So it's just an issue to be aware of and understand the difference. Just because your name isn't on the first page of the trust does not mean that you don't have a grantor trust. All of our land trusts are grantor trusts. So if you fall into one of the exemptions for 593C, you should be okay. And the exemptions include an LLC. It does not include an individual, though.
Okay, great. Thank you for clarifying that. Now, if everybody would get their trust agreement in front of them, we are on page, at the bottom of, bottom of page 2. It's paragraph 1.1, creation of the trust. Let me mention something, Lynda, just to clarify on what you just mentioned on that 3.3% tax. That's on the gross sales amount, not your equity, right?
Correct.
Yeah, so you could have no equity and owe them money.
You can get a refund. Actually, there's another form where you can show that there's zero gain or loss.
If you have zero, then you're exempt. But if you could have just enough to cover your tax and walk with nothing, right?
Yes, absolutely. That's California.
Yeah, that's California.
Randy?
Right, so 1.1, the purpose
Randy?
of the trust. Yes.
The same individual, capped 59, asks, simple question, he says, but would you consider having a corporation be your trustee?
Well, I'll give an answer, and then you can give an answer, Lynda. I personally don't like to use corporations or LLCs as trustees unless they are professional trustees that would be insured and bonded and that sort of thing. But I always get this question, well, can't I, as a real estate investor, use my own LLC as the trustee of my land trust? And for a couple reasons, I think it's a bad idea. Number one, if it's also the beneficiary, you certainly don't want to do that because you don't want a merging of interest. But number two, it's that at some point you're going to need that trustee to sign a document, either a deed or a mortgage, because you're putting debt on the property. And whoever signs on behalf of the corporation is going to have to prove that they're authorized to sign on behalf, which means either corporate minutes or perhaps even if it's an LLC, exposing your operating agreement to somebody that you don't really want to expose it to. I don't think you should show anybody your operating agreement unless they sue you to get it. So it's just much easier to have either an individual that all they need is their personal name notarized, or if you have a corporate professional trustee to serve as your trustee, one or the other of those. What do you think, Lynda?
Well, I agree as to the fact that your own LLC or your own corporation will expose you, because when you sign papers, you either have to show the operating agreement and that you have the power to sign, or you have to show your authority under a corporation. I do have some, what I would call kind of sneaky clients who will have another person who is, a small member of an LLC, a 1% or a 2% or even 5% member who will sign, or a managing, an LLC can have an outside third-party manager, that is not an owner. So a third-party manager of an LLC could sign for that LLC. So there are ways that you can get around it. I've had people use DPAs. There are a number of clever things, but it depends on how clever you want to be.
Yeah.
And every time you think you're getting more clever, you're adding more risk.
Good point. Okay, I guess we better move on, or we're going to run out of time.
Okay.
Paragraph 1.1, the purpose of the trust. This trust shall be revocable or irrevocable. That's a decision that you need to make. That's why we put it in parentheses. And then we went on to say that if you make it irrevocable, you leave the following paragraph out. I'm sorry. If you want it to be irrevocable, you leave that paragraph in. If you want it to be revocable, you take it out. Right, Lynda?
Which paragraph are you referring to?
The one that starts, the grantor shall have no right. In 1.1, purpose of the trust.
Mine doesn't say that. Do we have a different version of the trust?
Well, I don't know. That's a good question.
Read me what you have there.
Because mine, we put a note in there in bold print that says, note, if you want to create an irrevocable trust, include this paragraph, otherwise leave the following paragraph out.
I must have taken it out because I have to say that I never use irrevocable, and I'll tell you why. Because sitting here in California, if you in fact use an irrevocable land trust, you definitely will have a withholding tax problem. The seller is the trustee, and the trustee has no exemption. If it's a grantor trust and the beneficiary has the right to revoke, you have a shot at having an exemption from this withholding tax. So here in California, I just tell people you really shouldn't use an irrevocable trust unless you absolutely have to. Then you have to get your own EIN, and you have to pay this withholding tax, and then you have a property tax reassessment issue. So there's a number of reasons why I don't use that. So I think in my version, I took it out.
Well, probably because you're doing California trusts all the time.
Mostly California, correct.
But now, how does the 12-year rule work on that issue?
That is exactly one of the issues. If you shift ownership for an irrevocable trust for more than 12 years, 12 years or more, it's deemed to be a change of ownership for reassessment for property tax. So,
okay. So you can form a California trust for 11 years and 11 months and make it irrevocable?
And come back to you.
And make it irrevocable.
Yeah, but if it goes to somebody else at the end of that time, then you still have a change of ownership, right?
Yeah.
If you say, we're going to do this for 11 years and 11 months and a few days, and then it's going to go to you, Randy. Well, didn't I change the ownership? Yes. That's going to be reassessed anyway. And we'll get to that when we get to that paragraph, and I think it's
okay. Well, let's jump on over to, we're on page 3. The top is a continuation from the paragraph from page 2, and so that's either going to be left in or deleted based on the instructions we've given you there in bold print. So the next paragraph that we want to talk about is the trustee shall hold title to real property and protect, conserve, administer, and distribute the real property described in the schedule of the trust property, which is attached here to and made a part of this trust agreement. I just want to point out that the trustee is holding title, and not everybody gets this point that they don't own the property. The trustee owns full legal and equitable title to the property. If you're the beneficiary, you own the beneficial interest. You own the trust, and that's personal property, not real estate. So I just wanted to point that out, and also point out that the attached here to part is the very last page of the trust agreement, which is page 36, where you put the schedule of trust property. So you put the legal description and the common address, 123 Vine Street, for example, on that very last page, and that indicates what property is going into this trust. What are your thoughts on that, Lynda?
One comment that I get from clients is, I put that on Schedule A. I have the street address, I have the legal description and the APN number, but when I've sold this, can I just take that page off and buy another piece of property and do another Schedule A or Schedule of Trust Property? And my response to that is, I wouldn't do that if I were you, because anything that happened on the prior piece of property, if somebody discovers later that they want to sue you, now they're going to sue against your new piece of property. So I say, don't do that. This is one trust, one property, and that's all.
Yeah, and since it's so easy to set these trusts up, why not just create a new trust for each property and not have any possible continuing liability that could come back and bite you later on with a whole new property in that trust.
Randy and Lynda, this is Andrew. I'm jumping in because we had a question from someone saying that they're having poor connection problems and it's difficult for them to watch. They're wondering if there will be a rebroadcast available. And the answer is yes. This will be on YouTube later this week, and if you're on Randy's email list, you'll get a notice letting you know that you can go to his blog or to YouTube to watch this recording.
Thank you for that. Okay, did you have any other comments on that paragraph 1.1 that you wanted to make, Lynda?
No.
Okay. I think we've only got about 10 minutes left. These broadcasts are limited, folks, so we only have so much time, and then they cut us off.
Randy, we have another
yes.
question from @Lance Leitner, and he says land trusts are somewhat legal in North Carolina. He wants to know what your thoughts are.
Well, North Carolina does not have an actual land trust statute, but they are legal. You may or may not have difficulty getting help forming a land trust because probably most of the attorneys in the state aren't knowledgeable about them. Not that they're not smart, it's just they haven't studied them to learn about them. And if you're a member of the Land Trust University, my Land Trust University, you received as one of the bonuses my 50 states trust laws. And so I gave you 50 Word documents, one for each state. So go to North Carolina, open that file up, and you'll see everything that I know about land trusts in that state. Also, if you have my course, you've probably read it and hopefully read it and understood the fact that just because you're in North Carolina doesn't mean you have to form a North Carolina land trust to hold title to your property there. And in fact, there are many benefits to forming a trust outside of your state to hold title to property in your state. And while that subject is way too deep to get into on this short broadcast, it's covered in detail in my home study course. So if you don't have the course, then contact me at that email. Again, it's randy@mrlandtrust.net. In a minute, I'll ask Lynda to give out her contact information as well. Lynda, this was emailed in, and we may not have time to cover it, so I'll let you be the judge of it. But I know you do a lot of investing with IRAs, Roth IRAs, and land trusts. So here's the question. The stakes are very high if a Roth IRA does a prohibited transaction. Has there been any research confirming that the IRS purposes, for IRS purposes, the addition of a director to a land trust does not interfere with the trust classification as a grantor trust, as the term is used for federal income tax purposes?
Well, that's a long answer. The role of director may be different and differently defined under state law of any particular state. In some states it would be considered to be a fiduciary. In some states it wouldn't be considered to be a fiduciary. And then it depends on whether the director has, what rights you've given the director, because we give directors various different rights. So if the director has the right to revoke, that person may be deemed to be the grantor of the trust as opposed to the real estate investor. So that it's a complex question, a very complex question. I'm not going to be able to answer all of it in a couple sentences.
Okay, well, I think that's probably all we have time for now. I would like you to get out your contact information if you want to, Lynda.
Okay,
email and phone number.
I'm actually going to give a different email than I gave last time because this one is far easier, and I check it all the time. It's my name, Lynda Sands, and make sure Lynda is spelled with a Y, so it's LYNDASANDS @me.com, which is a Mac mail email address. It's best to contact me through email. It seems like on a work day I'm constantly on the phone, so I answer emails probably more rapidly than I do phone calls. But if you want to call, it's 858-750-3410.
Okay, thank you for that. And for those of you who are subscribers to my monthly Land Trust University coaching call, where we talk about land trusts and corporations and LLCs and privacy and asset protection subjects, here's a reminder that the next call is on April 23rd. That's a Saturday morning at 11 a.m. Central Time. And as usual, I'll send you 2 emails prior to that coaching call, so you can put that into your schedule. In the future, we're going to continue breaking down the trust agreement. So if you'd like to be notified when I'm having my next live Periscope, send me an email and just put add me, ADDME, in the subject line, and send it to randy@mrlandtrust.net. And that way I'll add you to the email list, and you'll get a heads up earlier in the week. You can also follow me on Periscope and Twitter at Mr. Land Trust. You probably have some friends and peers who could benefit from what we're teaching here today, so a great way to strengthen and grow your network is by sharing with them. So please do that.
Randy, this is Andrew.
Yes, sir. Go right ahead.
I wanted to let you know that we've had several people who have thanked you and Lynda for your willingness to share. Here's one that won't get covered today. It's just coming in from @ESP Tribal. I'm interested in tribal land trust. That's a whole nother wonderful topic. And I also had a question from @JAI_preference, who said, I'm interested in business and land trusts. Would you help? And I kind of think that's the whole purpose of these calls, right?
Yes. While we're limited on what individual help we can give on these calls because we are so restricted on time, certainly you can email either one of us, Lynda at her office and me at mine. We'll be glad to help you out as best we can. Do realize though that if you're consulting with Lynda, she is an attorney that works for a living, and will charge accordingly. So expect to pay for that expertise that she has. Anything else, Lynda, on your end before? I know we don't have our next scope date and time set. We will notify everybody by email, which is another good reason to send me that add me email, so you'll get an advance notice. But anything else you want to add before we end this call and be forced to end this call?
No, I think if we have the date and we can tell them we're going to continue on, this is sort of a serial adventure here where we're going to go little by little through the trust so people understand how to use this trust. I think it'll be very, very good for people.
Yeah, I think so. We get a lot of good feedback. Got a lot of good feedback at the last one. We had 144 people watch it live, and I think over 150 or so that watched the replay so far. So it's already picking up steam. So thanks again for your time, Lynda, and we will see you next time, okay?
Thank you.
Bye-bye.